Article 323 of the Indian Constitution is part of Part 14A, titled Tribunals, and it deals specifically with administrative tribunals. Here's a detailed explanation in simple terms. Purpose of Article 323A. This article authorized the Parliament to create administrative tribunals to resolve disputes related to recruitment and service conditions of people working in central government, state government, local bodies, other authorities and corporations controlled or owned by the government. Clause 1. Parliament may pass a law to set up tribunals for handling disputes involving appointments, promotions, transfers, salary issues, service conditions of government employees. These tribunals can deal with cases concerning employees of the union, central government, any state government, local authorities like municipalities, corporations under government control. Clause 2. What can the law include? A law made under Clause 1 can provide for a. Separate tribunals, one for the union and separate ones for each state, or a common tribunal for two or more states. B. Tribunals' powers. Define what powers and authority the tribunals will have. This includes the power to punish for contempt, similar to courts. C. Procedures. Set the rules and process the tribunals will follow, example time limits, evidence rules. D. Exclusion of courts. All regular courts, including high courts, are barred from handling these service matters except the Supreme Court under Article 136, Special Leave Petition. E. Transfer of cases. Ongoing cases in other courts, before these tribunals are set up, can be transferred to the new tribunal if they fall within its scope. F. Changes to Article 371D. And amend repeal orders made under Article 371D. 3. Special provisions for Andhra Pradesh and Telangana regarding public employment. G. Extra provisions. Any additional rules needed to help the tribunal work effectively, such as court fees, enforcement of decisions, speedy resolution of disputes. Clause 3 overrides other laws. This clause says that Article 323A will apply even if it contradicts any other constitutional provision or any existing law. In other words, this article has overriding power to establish and run administrative tribunals. Key objective: to reduce burden on regular courts and provide a specialized, faster, and focused forum for resolving government service-related disputes. Example: the Central Administrative Tribunal, CAT, was created under this article to handle disputes of central government employees. The Constitution of India. Part 14A. Tribunals. Article 323A. Administrative tribunals. 1. Parliament may, by law, provide for the adjudication or trial by administrative tribunals of disputes and complaints with respect to recruitment and conditions of service of persons appointed to public services and posts in connection with the affairs of the Union or of any state or of any local or other authority within the territory of India or under the control of the Government of India or of any corporation owned or controlled by the government. 2. A law made under Clause 1 may a. Provide for the establishment of an administrative tribunal for the Union and a separate administrative tribunal for each state or for two or more states. B. Specify the jurisdiction, powers, including the power to punish for contempt, and authority which may be exercised by each of the said tribunals. C. Provide for the procedure, including provisions as to limitation and rules of evidence, to be followed by the said tribunals. D. Exclude the jurisdiction of all courts, except the jurisdiction of the Supreme Court under Article 136, with respect to the disputes or complaints referred to in Clause 1. E. Provide for the transfer to each such administrative tribunal of any cases pending before any court or other authority immediately before the establishment of such tribunal as would have been within the jurisdiction of such tribunal if the causes of action on which such suits or proceedings are based had arisen after such establishment. F. Repeal or amend any order made by the President under Clause 3 of Article 371d. G. Contains such supplemental, incidental and consequential provisions, including provisions as to fees, as Parliament may deem necessary for the effective functioning of, and for the speedy disposal of cases by, and the enforcement of the orders of, such tribunals. 3. The provisions of this article shall have effect notwithstanding anything in any other provision of this Constitution or in any other law for the time being in force.